Glad to have you all back today. Good day to everyone. We're here on an expanded set this morning because we have a few extra guests with us today to talk about some important things that are going on in our country. And it's not just Ohio, it's nationwide, and it affects all of us. I have a co-host this morning. We have Dr. Tom Roberts. He's our political action chair here for Dayton, and he's going to co-host with me this morning. And as our guest this morning, we have Professor Vernella Randal at Emeritus. Yes. That's right, from UD. And we have, hi. We're glad to have you all back today. Good day to everyone. We're here on an expanded set this morning because we have a few extra guests with us today to talk about some important things that are going on in our country. And it's not just Ohio, it's nationwide, and it affects all of us. I have a co-host this morning. We have Dr. Tom Roberts. He's our political action chair here for Dayton. And he's going to co-host with me this morning. And as our guest this morning, we have Professor Vernella Randal at Emeritus. Yes. That's right, from UD. And we have Attorney Michael Thompson, and he's shares a office with Mia Spells. They have an attorney's office. And then we have the former mayor, Mr. Clay Dixon, and he's also the head of the Miami Valley Organization for Collaborative, Organizing Collaborative. I'll get it all right after by the end of the show. And we've expanded the time we're going to spend on this talk today, and it's about the stand your ground laws as we have it currently here in Ohio, the way it is, the way they want to change it, and perhaps getting some thoughts on just exactly what it means. And I hand it over to you, Tom, to give us a start.
Okay, very good. Thank you all for being here. The NAACP had our national convention this year in Orlando, Florida, which is roughly 20 miles south of Sanford, where the George Zimmerman trial took place. And shortly after the verdict, the national president, Ben Jealous, and the chairman of the board, Brock, brought our young people together and had a conversation with them around this verdict. And a lot of people were just upset about it. And a lot of us were looking at it, you know, I can't protect my child anymore. You know, my child can't go to the store and come home without being accused of something and ending up dead. And so I thought it was important enough for us, and the national thinks it's important for our state conference and our local units to have conversations around this issue of changing the self-defense laws. And just to get started, no less than, since 2005, no less than 10 states have changed their self-defense laws, which basically grants immunity to individuals who use deadly force as a mode of self-defense. Now that's a drastic change in what many states have had. So Michael, let's talk about that for a moment. Let's talk about what Ohio law looks like, what this whole issue of self-defense looks like, and what does Ohio currently have on the books?
Okay. Presently, Ohio, in terms of self-defense, the laws are basically, we fall under the stand your ground. What that means is, it's called the Castle Doctrine, and although I'm not exactly certain, I think castle comes from the idea of your home is your castle.
Right.
So that's C-A-S-T-L-E, and what that, the law as in Ohio now, in self-defense, in terms of self-defense, the Castle Doctrine does apply. And what that means is that in your home, you do not have a duty to retreat, which in other areas, in order to assert a self-defense argument as to try and get to a justifiable homicide, you do not have, there is a duty to retreat.
Okay.
That means if someone approaches you, a criminal, with the intent, if you believe that that person will either cause harm to you, to someone else, or to that particular home, you can, and you use deadly force or some kind of force to repel that person, you can make an argument for self-defense. So you don't have the duty to retreat if you're under the Castle Doctrine. If you're in the home, in your vehicle, or if you're in someone related to you's home. In terms of Ohio, that's one limitation. You do not have to, normally you have a duty to retreat. Under the Castle Doctrine, if you're in your home, your vehicle, or someone related to your home, you don't have to, you don't have a duty to retreat. You can, before using some kind of repelling force or deadly force or violence to assert that. That's where the law stands now. Presently, there's legislation to the effect to expand that to where it's not just your home or vehicle or your someone else's home that is related to you. Basically, now the expansion would be as long as you're in a place that you have a right to be. You no longer have the new bill would be, you no longer have a duty to retreat before exercising that reasonable or exercising that repelling force.
Let me ask you this, Michael. When I was in the General Assembly in 2008, we changed the law to the Castle Doctrine, and then it was amended again in 2011. What was the law of the land, if you remember or recall, prior to 2008?
As I recall, the law would have been that you, in your home, you know, the Castle Doctrine, you could assert self-defense as long as you could show, or requirement was that you show that you could not retreat.
Okay.
You know, if you could show that. If you couldn't show that, then of course you couldn't assert self-defense as a defense.
Because we used to always have that joke, Mayor. You remember that? If make sure if you shoot them, you drag them in the house, right?
Right.
You know?
Right.
And so how does House Bill 203 change this language, or is it 208? How does it 203? How does House Bill 203 change what Ohio currently has as a Castle Doctrine?
Well, let's start off by saying that, number one, that we are not trying to take anyone's rights away, oppose anyone's right to carry a concealed weapon. And as you've been mentioned, we have already have very strong laws in the state of Ohio that one can protect themselves. That's already on the book. It has never been a major issue in Ohio up until now when they're trying to change the law. And the duty to retreat, you know, right now, if people say, I don't have to retreat, I can stand my ground anywhere, what that's going to do is polarize the community. And you know, we don't want to make it a race issue, but we know that stand the ground is becoming a race issue simply of what happened in Florida and the other states that are changing the laws. And there are other changes in the law that I'm concerned about also. One is that the law makes it easier, the proposed legislation make it easier for other individuals to come into Ohio to get a permit to carry a gun. I mean, and their laws may be different from our laws, but they make it just easier to come in Ohio and carry their law. And then another part of changing it is the education part. You know, the training that you have to go through. They want to lessen that, where, you know, which is very important is the range training, the gun safety, all those kinds of things. In the proposed legislation, they are talking about reducing that and actually cutting out some of the safety components.
So again, just so the audience is aware, House Bill 203 does have the stand your ground, but it also has many changes to our existing concealed carry law.
It has a wide range of changes of the existing law. Okay. And I just mentioned a couple of those.
Okay. And as I understand it, Carolyn, the Ohio Legislative Black Caucus has opposed the entire bill. I think the Police Chiefs Association opposes the bill. I'm not sure about the prosecutors. I know they opposed it in Florida. Are you aware of their
the
position?
Ohio County prosecutors are opposing the legislation.
Okay.
As well as the Ohio Police Chiefs Association.
Right.
Are opposing the legislation.
I was at a town hall meeting about a month ago where the attorney for John Gilchrist for the police chiefs was on the panel, and they talked about it, their opposition to it, but they were also opposed to the law when it's in Florida. So that's a very disturbing aspect of it. Dr. Randal, let's have some conversation with you. This is a major shift in what we as Americans value and what we think. Give us some insight as to your perspective on this.
Well, it is. And I think the thing that people have to start with, for me at least, is to start with the idea that understanding that all law represents values. Mm-hmm. So that you don't, when people say, well, law shouldn't, we shouldn't institute values in the law, then the answer is, well, all law. You can't think of a law. You tell me a law, I can talk to you about the values that are represented in that, okay? And that, and then we know that. I mean, we know that as African Americans because we've been both on the side of the law calling us property to now, okay? So then one of the things I think that is sad in a society is the lack of history. People seem to think that what we have now, current day, we've always had. But we used to live in a society where it was shoot first, ask questions later, okay? That there was a time in our society where everybody had pistols, everybody packed their pistols, and everybody shot at each other, and then whoever left standing got to tell the story of what happened, okay? And we went away from that for very good reasons, because we began to be a society that said we don't want to resolve our disputes through violence. We value rule of law. We value people going to the law to the extent possible to resolve disputes. We value people mediation, negotiation, discussion. We want people, if at all possible, to do that because we value that. And so we moved away, we moved self-defense into you are entitled to defend yourself. That's a long-standing, we got it from England, that's not a new thing. But we don't want you to use violent, deadly force if in fact you don't have to. Right. Now, no one's saying that if someone comes after you with a knife, you're supposed to, or a gun, that you're supposed to try to run. You can protect yourself from deadly force. That's always been a part of self-defense. What we're saying is you should not use deadly force against someone who is not using deadly force against you, and you should retreat if you can. And what the stand your ground laws do is change that, saying that person doesn't actually have to be using deadly force against me.
Right.
I just have to be fearful that they're going to use deadly force against me. And now I can use deadly force against them without even knowing whether or not they got a gun, whether or not they're going to use a knife. I just have to have reasonable fear. And we can get into a discussion of what that means.
Well, go ahead.
Go ahead.
Well, I mean, what you're talking is what we were raised with. If there was a fight going on, the last thing you want to do, if you can get away with not hitting that person, you did. And you would take your child and say, well, I don't want you out here fighting when it's unnecessary. Come home, tell me about it. And now we're reversing that, you know, saying, no, you don't have to, you don't have to come to me. Just, you got a gun, use it.
Stand your ground.
Stand your ground, don't
Stand
move.
your ground, don't move. Okay, so then you have to say, well, what kind of society is that kind of law building? Okay, what kind of values is in that society? Because it's correcting a problem that don't exist. Okay, if people could point to cases in which all these people were being shot in the back because they were trying to get out of the way of violence, and that had they stood their ground, they would be alive. No, they're just imagining, people are imagining times when they think that they might be afraid, and so when don't they want? I mean, we have to ask yourself, and I think this is about race. I think that people are imagining a new world in which that the white majority will no longer be the white majority, but they will be fearful of the other people, and they don't want to have to run or move their ground.
Okay.
So I think and we can talk more. Like we got plenty of time.
Let me ask you, because you said something that I want to get cleared on, clarification. Because there is something in current law, I guess, that deals with equal force. In other words, if you have a gun and I have a knife, that's not well, tell me a little bit about that, because I've heard people use that. Is it such a thing as equal force? You having
it's deadly force.
Deadly force. Okay.
Deadly force, and Mr. Green probably could talk about this more because he's practicing criminal law. But my understanding is it's not necessarily equal force; it's deadly force. So a knife, and it can be none. I mean, you know, it doesn't necessarily have to be even gun and a knife. It is that are you using a force that is reasonable likely to cause death or serious injury?
Okay.
And then you can use force against that.
It's called equal force. No. How would you call Michael or Mayor? How would you define what we're talking about there? Yeah.
I think where we're going is, if a person comes at you with a fingernail clipper, now, you know, small blade, in all likelihood, not a deadly weapon.
Okay.
And you in turn pull out a gun and shoot him. Right. And you say, well, he was coming at me with something that, you know, I feared would cause me deadly. You know, he could have cut my throat, my neck, or something. But, you know, in the normal circumstances, you'd say, well, really, to be honest with you, it was a fingernail clipper, and then you overly extend yourself to rebut that force with something of a substantially greater ability to cause harm. Okay. You know, you pull out a shotgun and you hit a fingernail clip. You say, well, I don't know, you know, theoretically that could have caused me deadly force.
Okay.
And so I met that with what I perceived that I had to repel it, which was no doubt deadly force.
Ray, did you have a comment on this?
Yeah, just the entire intimidation factor. You know, when you add in the duty to retreat, and if I fear you because of your, you know, appearance, you know, that I'm just thinking that you're going to bring bodily harm to me, you know, then I may be able to do something to you, and that goes back to the racial factor. That put our youth, the black youth, at a high level of risk, you know. You heard the kind of examples where you walking down the street and a young black male walk past you and they clutch their handbags, they you know, kind of get nervous and things of that nature. So when I say it becomes a racial polarizing this law, you know, it's simply because already there's intimidation in terms of who we are, the way that we look, the way that we dress.
In fact, at the town hall meeting in Columbus, a white female asked the panel a very good question along those lines, Mayor. She said, what if I was standing at near a bus stop and had my purse in my hands late at night in the inner city, and a young black male was running to catch the bus, and I thought he was running at me. What do I do in that situation?
Wait and see. I mean, the thing, you know, I was telling, I have, my sons are men now, in their 40s, okay? And there was a point in my life where, because I think that you can't live in an American society and not get those stereotypes, biases, and prejudice, and even black people have them, and even I, who teach race and racism in American law, and who had raised two sons, and had fathers and brothers, I found myself at a point where I would see young black men approaching me, and I would get a little bit fearful, okay? And I recognized that as a stereotype, that it wasn't based on anything they were actually doing. And I had to train myself to stop reacting and to just not lock the door, not clutch my purse, wait and see. And because they do the same thing for whites. I mean, the fact of the matter is when a white male is running towards the bus stop, is the first reaction, oh, he's got to come and rob my purse? No. The first reaction is he's probably running to catch the bus. And then if he starts acting threatening, then you do something. But the problem with the stand your, and this is the problem with the stand your ground law, is that it allows people to act on their first reaction, and by the time they figure out that this is just the kid that was running to the bus, someone's already shot. And because of the way the stand, at least I don't know how the one here in Ohio will work, but the ones in Florida work, you should shoot to kill. Because the whole idea is that the behavior has to be reasonable, and if there's no one to tell their side of the story, then your story becomes the only the only kind of story to tell.
Well, I think Carolyn wants to ask a question, but let me just say that as I read, and Mayor, tell me, and Michael, tell me, the language in House Bill 203 is identical to the Florida language. Is the way I read the language in House Bill 203.
That's the way that I read it. What it actually does is gives an individual. Makes it easier for an individual to use the self-defense law. You know, if you come after me, I don't have to retreat, then it's easier for me as an individual to pull my gun and use the self-defense.
Self-defense. Yeah.
I like the point that Professor Randal brought out, that it takes that caution away from a person. I mean, a person, stereotypes of what they are, and they're influenced by the media, but they're oftentimes incorrect. And given that, I think people need to stop at a certain point and say, well, maybe my stereotype isn't what this is. Is there another reason? But in effect, stand your ground, to me, encourages vigilantism. Some people, other than the law, the requirements of the law, they would tend to listen to that first voice. And so we're creating a situation where that vigilante instinct that is often incorrect, as in Trayvon Martin or other cases, is not held in check.
And we're creating a culture that, this goes back, the value, what we're doing, this is not, the whole thing about what kind of society do we want, we have to look at a law like this as creating a value in the society that will then can be built upon for other kinds of values that go along the same line. Okay, so the thing I think about is slavery. Most people think of slavery in terms full-blown 1850. Illegal to do this, illegal to do that, sell all. But the reality is that slavery did not exist on the shores of the United States. The first black people came here did not come as slaves. They came as free people, indentured people, like indentured whites. And then somewhere along the line, they decided that they needed a permanent slave force, and they began gradually to change the law. And it was one law at a time. They didn't put forth a huge, big old 600-page bill saying this is how we're going to change the United States. Every time they got a little tiny problem, they would change the law to fix that problem, because they had in their mind was a society in which slavery exists. And so anything that threatened slavery, they then passed a law. So what we have to ask ourselves is, what kind of society are we building around these kinds of laws, and where will that take us in ultimate laws? If we think that this is this is kind of like the end stage, I think that's a mistake. I think this is an interim law to build a system in which fear of the other will justify behavior that it didn't justify 25 years ago.
Well, I think that has begun, because I've seen kids on the playground playing, and they were playing at first and pushing and shoving, got a little bit more, and the kid jumped up talking about, I can stand my ground. If I had a gun, I'd shoot you. And I'm saying, like, whoa, wait a minute, hold on. I mean, if we are doing this, and I said these kids were about 7 or 8. If we've got kids at 7 or 8 hear this and say, I'm going to stand my ground, not realizing, not having the background to know that that's not a reason to do this, then society has already started to build that in.
Yes.
And when you see, in this particular case, I've seen it several times, but these were young black males.
Right.
And if this is the mentality it's starting to develop, to me, that's a lost society. If we're losing our kids down here, we can't wait till they're 15 or 16 and they can get a gun, because some are in other places, they're getting guns at 8 or 9. So how do we work to turn this around? Even if the bill passes, how do we work as a society to change that, or to work on our children not growing up to think this is the way?
But then the question becomes, if we allow the society to be a change, is that reasonable for us to do that to our kids?
Right.
If I mean that, if people are going to be buying guns and stand their ground, shouldn't we be arming our kids? And say, why are we going to disarm our kids in a society in which the rest of the society is armed? And that's the danger of this slope that we're on, because if we move away from the rule of law, if we move away from dispute resolution type of mode, the alternative is you have to prepare your kids to protect themselves in the society they are in, not the society you wish they were in.
Just help me understand rule of law. What does that mean?
Okay, the rule of law is a term of art which society, in terms of how we have laws and we resolve our disputes by the law.
By the law.
Okay. We don't dissolve our disputes through self-defense, through self-help. Okay, so you could, for instance, as an alternative to rule of law, we could say we want a society, if you can't protect your property, that's your problem. If you can't protect your life, that's your problem.
Survival of the fittest, basically.
Exactly.
You know.
That would be one way. Rule of law says, oh, no, 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 no. Don't solve disputes that way. When you have a problem, go to somebody and let them help you figure out a way to solve it. You know, and
that's a core principle of America. Because I hear politicians talk about it, lawyers talk about it, but the rule of law is embedded in the cornerstone of this country.
It has been a part of the cornerstone of this country for the last 150 years, maybe 200 years. I think the thing we have to realize is that it was not always a part of, and we moved away from the you take care of your own property because that wasn't working.
Right.
You know, there was a point in our nation history in which, pretty much it was, gunsling. You had to take care of your own property.
Right. The Wild West.
The Wild West. That's it. Yes.
And I was raised, watching the Western movies.
Yep.
Oh, yeah.
And I know that when Wyatt Earp cleaned up Dodge City, he implemented a gun control law. Where
He did, right?
and when they did that, when they had gun control, where you cannot bring your gun into the city limits, that cleaned up the city back then.
Right.
And all I'm suggesting is the direction that we're going. We are giving people more opportunity to utilize shoot first and ask questions later, right? That kind of concept.
But can because is it? I mean, but can the Second Amendment, my right to bear arms, and the Castle Doctrine stand side by side and not be contradictory?
They don't contradict.
Okay.
Not at all. They have nothing to do with each other.
Many people will say, this is a violation of my Second Amendment right.
It's because they don't understand Second Amendment.
And so let's help them understand it. And why would you say it's not a violation of my Second Amendment right?
Because you have the right to bear arms. You have the right to protect your home and your family. What we're saying, when they're expanding, they're trying to expand that right out into community situation where people interact with each other all times. And if you feel threatened, that means that you do not have to have the duty to retreat. You could use that deadly force and use that self-defense as an excuse.
Okay.
And I think that's the issue. When can you use the self-defense issue? When you're not protecting your home, when you are not threatened with deadly force yourself.
Okay.
And now it's just out there.
See, I think people think the right to bear arms means the right to have no consequences from bearing them.
That's
good. You can't expect to say I can bear arms anywhere, anytime, and if I shoot anyone, then I should get off because I have a right to bear arms. No. You have the right to bear arms, but the society, because we live in a society, has the right to control when you will have consequences for shooting someone with that gun. Okay. And what we're saying is, up until this, we moved away from a gunslinger mentality society because that wasn't working, and to a you need to retreat unless someone is using deadly force. And now we're trying to move back to a gunslinger mentality, which is and as a society, we can say, you continue to have the right to bear arms. You can pack your guns on your side. You can go to meetings on your side. But if you pull that gun and shoot someone, we are going to control when you can use self-defense, and we don't believe that you ought to be able to use self-defense against someone who was not threatening you with deadly force.
Okay, I got you. Michael, go ahead.
Yeah, I'm going to direct a question to you. And I was at a Corinthian church, and you gave the history in terms of how the right to bear arms came about.
Right,
So could you just kind of
Well, if I remember, but there's been a major shift
yeah.
in our mindset,
Exactly.
and the Supreme Court ruled, like it was the Miller case, I guess, many years back, that was the first. But over the years, there have been a shift, because the Second Amendment basically was militia
Right.
in my home, and over the years, the law has the concept has changed. Quite a bit. Even the Supreme Court has changed its way of interpreting it, and has been my opinion, I think in several documents I've read, it was because groups were lobbying Congress, lobbying the Supreme Court to change it to go the way they've been thinking. So the whole Second Amendment has been changed over the last 100 years, because it was no big issue for many years, because everyone thought it was the militia we were talking about. And I think that's what the founding fathers intended to be.
It was I'd love to, because people drop off the first phase, and
Yes.
as a lawyer, you
Apply it to what you want.
Anytime you have
Yeah.
a clause with a comma,
Yeah,
the clause modifies the next things that follows it.
right.
I mean, that's basic English interpretation. So the Second Amendment says, and I like this because I remember, in order to have a well-regulated militia,
Okay.
comma, the right to bear arms shall not be abridged.
Right.
Okay, so you can't talk about the right to bear arms without talking about what does it mean to have a well-regulated
Militia.
militia.
Right.
And when we've, in the last maybe 100 years, we completely forgotten about that well-regulated militia. So, but even if we drop that off, I would still say, talking about the right to bear arms is just totally unrelated to whether or not you can shoot someone and have no consequences for it.
Are any of you aware of the Texas study, the Texas A&M study?
I'm not aware.
I'm not
Okay. And apparently there was a Texas A&M study done sometime last year that basically said when what defense was used by African Americans, there's a greater chance of them being convicted of the crime
Than whites.
Who
use the
who use the
defense.
same defense. And I think that is what our national president, Ben Jealous, used as a press release he did last June, the Texas A&M study. And so many people think that NAACP only came to the issue recently after the Trayvon Martin decision. But I think it's important people know that our national president, Ben Jealous, has been out front on this issue from the very beginning. But if you go back and look at the national website, June 13th of last year, Mr. President Jealous did a press release opposing Stand Your Ground and based on the Texas A&M study, but he gave those reasons. So I would encourage people to look at that study to see its impact on African Americans that use that as a defense and its likelihood of having a favorable outcome to them.
Yeah, on October the 2nd, it was 500 of us throughout the state that presented petitions against the proposed Stand Your Ground legislation in Ohio. And while we were doing our peaceful demonstration, there were other NRA supporters that actually had their guns strapped to them.
Right.
Walking around. It was only about 10 of them, but they actually had, their weapons strapped to them. And the police did absolutely nothing. They monitored the 500 people that we were presenting the petitions, but they watched us more closely than they watched the guys that were actually carrying those weapons. Okay, suppose that situation was reversed. Okay, suppose it was some black African American youth that were carrying guns during a protest. What do you think? How do you think the police would have reacted to us?
Much differently.
Much differently.
Yeah, sure. It seems like the whole issue, and one thing that strikes me is that when we opened, Tom, you noted that the prosecutors and the Police Chiefs Association were all against Stand Your Ground.
Right.
And when you think about it, any law that encourages a person to say, even if you just go by the name of it, stand their ground, when the opportunity to diffuse the situation by leaving or going somewhere or doing something else is now they don't have to worry about that. The law that required that you can only use your weapon in deadly force when there was no other alternative. It just encourages violence.
Yeah.
You know, if you have the opportunity to leave what you perceive to be a violative subject, situation, then, ultimately violence will ensue. Probably, and the possibility of unjustified violence is a part of that system. So what the law does, if the law sanctions something, the government comes down and says, this is okay, then you're just increasing the possibility that those situations will arise. If I'm faced with what I perceive to be a threat, and I say, oh, well, I could leave this, I could walk away and not suffer this possible consequences. But I say, no, I have a right. The law says, the government says, I don't have to leave this. I can stand my ground. Now I'm being encouraged by the powers that be to face this potential violence head on. Violence is going to be what happens.
Yeah.
Whereas if I say, well, I'm kind of afraid this guy is coming my way, maybe he's a robber, he kind of looks like, and that stereotype kicks in. Whatever it is, he looks like he could cause me harm. So I have a right to stand my ground. So I'm not going to try to avoid this. I have a weapon on me. Instead of leaving what might be some possible danger, I'm going to face it. Ultimately, I'm either going to get shot or I'm going to shoot someone. Either way, I'm perpetuating violence. And now, if I'm faced with that same situation and I say, well, it could end up this way, but I could just turn around and walk away. Mm-hmm. My better judgment might say, well, if I shoot this person, I don't have a defense because, I just have a feeling now and I'm acting on that feeling. But I don't have a right to stand my ground, which is how I think when the law initially was conceived, that was the purpose of, I have to retreat if I perceive that.
Right.
Michael, just to piggyback on that, and this was the paper I got when I was in Orlando at the National Convention, and it says, in 2006, investigation examined the first 5 months after the law was enacted. The Orlando Sentinel found 13 people in Central Florida were shot in cases in which Stand Your Ground was invoked. 6 died, 4 were wounded, 3 escaped, and only 1 person was armed. That goes to your point of the slippery slope that this law potentially can bring about.
Well, I'd be interested in knowing, Florida's law is pretty horrific. It's kind of the worst of the Stand Your Ground laws. All of them are bad, but Florida's is pretty bad because, one, it takes away the initial aggressors. So even if you're the initial aggressor, you can use Stand Your Ground if the tables are turned on you.
Okay.
So I start approaching you to start a fight, and in the midst of the fight, you start getting the best of me in such a way that I'm now fearful that I'm going to die. I can now kill you even though I was the initial aggressor. Florida law. Okay. Florida law also takes away the ability of the police to arrest. That was part of the problem. The police have to make the decision at the scene, and at the time, they have to they can't arrest. They actually cannot arrest someone where they think this defense might come up. And Florida law takes the ability away to sue in civil court. Remember, what got OJ was not criminal court, but civil court. They said, yeah, we lost in criminal court, but there's a lesser standard in civil court, so we'll just sue you and take all your money because you unreasonably killed our son. Florida law says you can't sue in civil.
Go ahead. I'm sorry. Go ahead.
In civil court. Yeah. So, I mean, I don't know that these are a part of the current bill, but once you start down these roads,
that's your point.
That's my point. My point is that even if you say this bill is not as bad as Florida law, these things become a natural sort of add-on eventually, because eventually you're going to have the problem of what to do about the initial aggressor, what to do if you know, people are being arrested and brought up to trial, and yeah, they can claim this defense, but they still got to go through the whole thing, and what to do about civil suits.
Well, let me ask Michael, let's go back to the history, because you said something that I found very interesting in your comment. We have begun to go down the slippery slope. The law prior to 2008, when we passed the Castle Doctrine, allowed me to defend myself in my home if I felt death.
Right.
Now, that then extended it to my car and my house.
Right.
You called this a stand your ground.
Yes.
So is this a modified version? The Castle Doctrine, is it a modified version? Or is it not as? How would you Castle Doctrine? Why would you call that a stand your ground? I guess.
Well, because in the Castle Doctrine, you don't have the duty to retreat, which I think is fundamental to a self-defense. Because if you're defending yourself for fear for your life, I think it should be required that, you know, there is some danger. If you can escape, then there is no danger. As long as you can escape. If you can, so one of the requirements of the law was that you had no way to retreat. You couldn't, before the Castle Doctrine, it was, you had to be able to show that that was part of the standard. So if I'm your lawyer representing you and you're charged with shooting someone, I have to affirmatively put on a case that says, and you were in a room, the doors were locked, you had to be able to convincingly prove that, in fact, there was no way you could have gotten out of that.
So someone broke into my house, running out the back door with my TV. That's what this is preventing me from shooting that person, because my life is not in any way being threatened at that point. So there would be a defense I would use, but the chance of winning would be. Yeah,
you'd have to prove that. You'd have to. That would be something a jury would be instructed to. If you find that he did, he could not, and then ultimately, then you have made your case for a reasonable.
Yeah, traditional self-defense required duty to retreat everywhere. Even within your own home. If you could retreat without killing someone,
you had to do it.
You had to do it. Okay.
And of course, a prosecutor would say, well, there was a door here, there was a telephone here, you couldn't use, or something, that in order to show that you could retreat.
I'm going to talk about how that law hasn't been applied to, there have been a number of cases in the statistics that you showed about from Texas A&M, but I think her name is Marissa Alexander in Florida, a young black woman who fired in the air to scare her abusive husband, and is now in prison because they would not allow her to use the stand your ground law. So the thing is anything, we know that the criminal justice system generally operates in a disproportionately negative impact on African Americans all across the board. And so I've heard some African Americans say, well, we need stand your ground because we may be fearful. And I'm like, yeah, do you really think that you're going to be able to use it to the same extent And it changes, and I keep going back to the fundamental value of our society.
Yeah. I'm just going to say, you know, we allow, you know, as a society, we have generally police officers. Now, they can carry guns, generally they can fire them well, and we've basically, I think, foregone that ability in a general sense to do that. Say, oh, okay, well, someone's breaking in my house, well, call the police. Or someone is waiting for me, they're arguing with me, I'm trying to avoid them. You know, we generally have the police to call. We've sanctioned them to carry weapons, to carry firearms, and in lieu of us carrying them ourselves. And one of the reasons why, from a policy perspective, is they're trained. We know they're trained, the training they have to go through. They're being away from the situation will maybe be able to exert some kind of reason and, you know, find out what the problem is and resolve that conflict. And I kind of understand why the chiefs of police and prosecutors would be against that, because now once you start, in essence, deputizing, you know, untrained individuals, giving them a license to carry firearms, you're putting citizens in the place of being that ultimate authority. You know, if I get into an argument with somebody and it looks like violence, and someone calls the police, generally their job, they're trained on how to possibly, if it's possible, diffuse that situation, you know, and if they can. Whereas by saying, okay, now we got stand your ground, you know, everybody's going to want to invoke that. You know, I'm in an argument with somebody, well, I can stand my ground. Well, that same person likewise can say, well, I can stand my ground. You know, and so now you got two people, you know, Mexican standoff, looking at each other, saying, I'm standing my ground, well, I'm standing my ground, and ultimately violence erupts. And you got individuals get hurt on a much more, I think I saw some statistics that show that even the assertion of justifiable homicide, self-defense, is now on the increase in those states that have stand your ground.
Right.
So it's become almost shoot first, and then we can
we'll sort it out.
Yeah, you know, each side, whoever is living, says, okay, well, I was standing my ground. You know, but that victim could have been very well make that same argument. You know, I mean, even with the Trayvon situation, you know, Trayvon, I mean, stand your ground, if it applies both ways, would apply to him also. Right. Someone stopping him, okay, he could have stood his ground. He didn't have the gun. Exactly. But, you know, it just encouraging violence.
Okay, I'm going to have to start wrapping this up. So I'm going to give you a minute, if anybody wants a minute, to have a final word.
I think what is very dangerous about stand your ground laws all over this country is the political climate of today. And something that Professor Randal mentioned is that we started off changing it, you know, law by law by law. And I think that is because of the political climate and laws like this, we're putting our youth at great danger because we are creating situations that's may cause people to use this law in terms of self-defense.
Okay. Sort of on those lines, I think we are embarking on a slippery slope, and the potential is really enormous when you think about it, because, you know, I personally never really perceived of the concept of like carrying a firearm or owning a firearm or anything like that. And I always sort of looked, well, situations come up, call the authorities before I even think about shooting someone. But with the laws changing, you really do have to sort of reevaluate any stance like that, especially in a situation where everybody's now carrying weapons and everybody's saying, I'm protected by stand your ground and my gun. And you know, the situations where conflicts can arise, where mistakes can be made, where judgment cannot maybe be as focused and as prudent as it should be, and violence erupts. So really, I think we have to, appreciating what the point Professor Randal has made, we need to stop before we embark on this slippery slope. Put the brakes on and let's think about it. Before we pass laws, let's, think about what the outcome would be if we go back to the Wild West days, to the days where everyone's carrying a gun and everyone's not afraid to use that gun. And people out of legitimate fear are making mistakes, or criminals are now asserting self-defense argument under a stand your ground principle. Well, I wasn't there to commit a crime. I was there and I saw he had a gun and I had stand your ground on my side just as much as it was on his side. So there's a potential for great confusion. Unfortunately, there's a potential for greater violence. And I think we as a society need to understand that before we allow a law like this to be ushered into or put upon us.
Yeah, I agree. I think that when we think about increasing violence in this society, as if it can increase even more, but it can, and I think we tend to be fearful of stranger on stranger violence, but the reality is most violence is acquaintance violence, and not stranger on stranger, and that the whole, everything comes to mind. I keep going back to Marvin Gaye and his death, and I think he'd be alive if there had not been a gun in his house. Right. He'd be alive if there had not been a stand your ground. His dad, like, I'm going to stand my ground, and before the law. And if we make that the sort of value of this society, then you are inviting people to resolve their disputes through violence, as opposed to resolving their disputes through the law, through mediation, through discussions, through a cooling down period. I think about my my grandmother lost 2 sons within a week from gun violence in the 30s. And I think, and this was at a time when that's fairly was fairly unusual. You think about what will happen to our society if, in fact, we begin to. It's not just going to be, increase in stranger violence. It's going to be an increase in acquaintance violence.
We'll have to end it there, Ms. Carolyn. I just want to remind and let the audience know that in response to the Trayvon Martin death, the NAACP nationally has come up with we call the Trayvon's Law. And if we can show that a little bit, it has 4 basic components, and one is racial profiling. The second part of it is civil compliance. And Mayor, we've had the Police Review Board for years, but the Civilian Compliance Review Board. The other aspect is best practice for community watch groups, and the final piece would be collecting data. So we will be looking at the state and local governments to enforce these 4 aspects as the NAACP goes forward to put in place what we call the Trayvon's Law. Carolyn?
Okay. Well, this has all been very interesting, and I'm sure our audience will find it interesting. And maybe somewhere down the line we'll come back again and discuss where things have gone. And I don't want to be remiss that our city commissioners did pass a resolution to send to the state against changing and going to stand your ground law. So I want to applaud them for that. And I have to make one other commercial break. Next Friday, the 25th of October, is the NAACP unit here. It's their 62nd Freedom Fund dinner, and it'll be at 6 o'clock at the Convention Center. Tickets are on sale at the office at 1528 West 3rd Street. Y'all come by and get a ticket. Come on out.
Thank you.
All right. Thank everyone for coming too.
Thank you.
Thanks, Tom.
Thank you for having me.